All rise. Order, we are going to order the sixth district of the state of Florida is now that Honorable J.P. Cohen, judge presiding. All persons having business before the court draw near and give attention and you will be heard. God save the United States of America, state of Florida, and this honorable court. Please be seated.
Good morning. This is on. Good morning. Oh, all right. Well, welcome to an oral argument session of the Sixth District Court of Appeal. We're the sixth, right? Yeah. Today. Yeah, today. We've got three cases on the docket this morning. We've got I've been introduced to my right. We've got Judge John Stargell from Polk County. To my left, we've got Judge Keith White from Orange County. Each side in these cases will be allowed up to 20 minutes each for their oral argument. If you don't use it all, there's no prepayment penalty or anything of that nature. If you would like anything other than 5 minutes of rebuttal time, let me know, and I'll be glad to adjust that accordingly. If you have any electronic devices, if you make sure they're on silent so that they don't interrupt the arguments. All right, I think the first case that we have on the docket is Miller versus Mann. Remember that these are being recorded on YouTube with a huge following of, probably upwards of 6-7 people. So up to 14. Up 14? Yeah, up to 14. Okay. So if you're ready to proceed.
I would like to reserve 5 minutes for rebuttal,
You got
please. And may it please the court, my name is Janice Rosenthal, and I have the honor of representing the appellant in this case, Bonnie Miller, DVM. I will oftentimes refer to her as Dr. Miller. This is a case of replevin involving possession and ownership of certain show dogs. And there were two peers.
It's probably surprising to you, but we actually do read the briefs in the record, so we have a pretty good feel for what the case is about.
Okay, Your
So
Honor.
let's start with this. You would acknowledge that it's not our function as an appellate court to get involved in the reweighing of the evidence, correct?
Yes, sir. I would acknowledge that the evidence in and of itself.
Right, because it appears that a lot of this is just factual, there's factual arguments about what the parties' intentions were in entering in this agreement for the welfare of these puppies. And the trial court listened to all the evidence, had a ream of text messages going back and forth that showed conflicting agreements as to what the contract was, what the agreement was between these parties. And so the trial judge listened to that and made a decision. How do we get past that? I mean, it just seems to me that that's what this case is about. If I'm wrong, please, enlighten me.
Well, Your Honor, there are actually two areas that we are asking this court to look at. One is the truncation of the plaintiff's presentation of her case. Another,
Parties agree to the amount of time that would be, for given a trial?
I'm sorry, Your Honor.
Wasn't there an agreement as to how much time, the trial would take?
Uh, I was not
No, I think there
attorney at
was.
that time, but I
I
believe,
think,
I
think
believe
a
there was.
specific agreement as to the length of the trial,
Yes, Your Honor.
and so
But-
what you get what you ask for.
However, Your Honor, you have to be able to present your full case, and there are
Well,
two
then
things
you
that
ask for-
happen.
If you can't present your full case, let's say that the trial court gives, 2 hours in a, hypothetically, in a trial, and each side gets 1 hour. Because that's the amount of time that the lawyers asked for. And so at the end of an hour, you're not done. Is that reversible error?
Well, Your Honor, I believe it is, and I say that it is
Or
because
then give
there,
me your best case that
okay,
you cite for the proposition that when you ask for a certain amount of time and the judge gives you that amount of time, that's error to hold the lawyer to the amount of time requested.
Your Honor, if I may, and I'm not being disrespectful when I say I believe there was more than that, because the lower court judge actually stopped the plaintiff from testifying to certain matters, stopped her initial testimony by stating that that information was provided in a prior 2-hour hearing.
Ms.
And that-
Rosenthal, what's the difference between what Judge Cohen did this morning? I mean, you could have chosen to continue on and to give us all the facts that are in the record. But he just said, we've already read it, and you went on, which is basically what the trial judge did here. He said, I'm familiar with all of these background facts. Why don't we get to this? Because you have a short period of time. You could have chosen to continue going forward. Your client could have talked all about the history and the facts, but the judge was trying to highlight the fact that you had a 4-hour hearing. 2 hours into it, he's going to have what he has on your case. So it appeared from the record to me, as a former trial judge, that he was trying to do your client a favor by focusing her on looking at these 700 pages, all of the evidence that was there, and pointing to why there was an agreement that she should get the dogs back in her club. How is that?
Okay.
How is it any different than what Judge Cohen did today?
Well, I believe that the case that is most relevant, or there are several cases, there's a line of cases about interrupting the testimony and truncating the closings, interrupting and making other observations that perhaps are not really the job of a court. One of those observations was, I'm sure your client will not go without a written contract.
Well, that sounded to me like pretty sound advice.
However, it does show some bias.
What
And-
advice does that show?
It shows that, and part of this is in the second argument, so just,
Okay, but that's okay. This is free form.
okay,
Yeah, the fact that there was no written agreement is what resulted in this situation that your client found herself in. Had there been a written agreement, it would have been simple, but it wasn't simple. And it ended up requiring a trial judge to make determinations as to the credibility of witnesses and make determinations as to what the nature of the agreement was, because it wasn't in writing. I mean, I can't fault it. I mean, you want me to, I don't know how you write that opinion. How do I write an opinion that says to a trial judge, saying that that it would have been a good idea to have a written contract constitutes reversible error?
it's a combination and a culmination of things that happened. There was an initial hearing, okay, for temporary possession. In that initial hearing, the defendant or appellee took the stand and gave testimony, and the hearing was ended prior to cross-examination. There was no cross-examination and she still awarded temporary possession to the defendant. That to me is reversible error. Truncating a case, putting it on a stopwatch where,
Did you move to recuse the judge following that, that first portion of the hearing?
Your Honor, I was not at,
Okay,
I
all right,
was not at the hearing and I was not the
Okay,
attorney
was
at
there-
that time.
All right, I'm saying generic.
Yeah.
The generic view. Did your client move to recuse the judge following the conclusion of that first portion of the hearing?
I do not believe my client did. And I only say that because the judge did promise that a cross-examination 6 weeks after the fact, after possession, a temporary possession was given to the defendant without cross-examination. That
Well,
the hearing,
possession wasn't given to the defendant. The defendant was in possession of the dogs, and what the trial court did was to say, well, I'm not going to effectively grant this replevin action at this point in time.
again, Your Honor, I think that the problem with that initial hearing and then the subsequent permanent hearing, or permanent possession, is that cross-examination never took place. And it didn't take place because if there were to be a cross-examination, it was to take away from the time of the case in chief of the case that was being presented. So there is an issue of, do you do the cross-examination or do you try to put on your case? You're given 2 hours.
I want to make sure I understand. You're saying that after the expiration of the temporary hearing, did your client move for continuance and schedule additional time if the judge wouldn't hear it?
My client moved for a continuance in between the two of them.
Okay, so at the time that it occurred, when you were there for the temporary hearing, the time expired. They didn't ask for continuance, and then later they asked for continuance. But you're suggesting that the judge should have granted your client possession when that hadn't been concluded?
Well, in reality, I'm saying that possession, period, meaning you had temporary possession, which I without having a full hearing on temporary possession, even temporary possession should rightfully not have stayed with the
As Judge
appellate.
Cohen just pointed out, this wasn't temporary possession that was being awarded. This was a continuation of possession that had existed since your client met with her and let the dogs go with her at some point prior to that. So that's what I'm asking. Are you suggesting that because your client filed her replevin action, they had a temporary hearing that you said didn't conclude, that the judge should have said, well, let's give them back to Dr. Miller until we can finish out these hearings?
Well, it wasn't a matter of giving back because the services provided, this actually is very, very much similar to cases that were quoted or cited by the appellee in her answer brief.
If it's not a matter of giving back, then why is it replevin?
Well, because the appellee whelped those litters as a service to the appellant.
Well, but that's in dispute.
Well, again,
And that's what the whole trial was about.
well, and Dubin, which was cited by the appellee and her answer brief, Dubin says the AKC registrations are prima facie and must be rebutted by the other side. And Dubin actually was a case between a handler and an owner.
But wasn't your client the only one who is in a position to register them because the AKC requires the owner of the dam, I guess they call it,
Yes,
to do the registration?
And that's correct. And that's actually part of the point, part
So
of.
if,
point
just
is
following that line of thought. Somebody could go out and verbally say whatever they wanted to with the agreement. And then go to the AKC, register all the puppies and say, I'm sorry, they're mine. Because the AKC only recognizes me to file it. I filed it in my name, therefore they're mine.
AKC has a whole process of transferring ownership. Part of that it's kind of like a car where you have a registration and dogs are chattel.
And the AKC is, it's a rebuttable presumption, but you've got the series of, emails and text messages that, really call a lot of that into question, where your client referred to, the FLE as, a co-owner. Well, that's not what the AKC registration showed. And
And
so, that's rebutted. It's rebutted by some of the emails or texts that your client sent. So again, this just strikes me that this is coming down to a factual dispute between the parties. There was nothing in writing. And I don't know how, as an appellate court, we reverse the county court judge for this file.
again, I go back to the testimony that was given and not able to be given, and that there is a whole line of cases, some in the 4th DCA, one in the 5th DCA, that says that truncated testimony and interruptions, multiple interruptions, is reversible error. It is an abuse of discretion, and the cases were reversed and remanded, and I can give you several of those. And in the case Julia v. Julia, it states that due process requires that a party be given the opportunity to be heard and to testify. The denial of this right is fundamental error.
How much time did your client have?
I'm sorry,
How much time did the judge give your client to present her case?
my client received the 2 hours, but was interrupted multiple times when she was giving her testimony.
You're into your rebuttal time.
Thank you, your honors. Thank you so much
Thank
for
you.
listening and for asking questions.
Good morning, Marcy Lahart. I'm here on behalf of Chelsea Amend, the appellee. Dr. Miller has argued that the court relied inordinately on the initial replevin hearing, but cited to no evidence in the records to show that that was true. She claims that she was not allowed to put on crucial evidence, but didn't proffer that evidence and still hasn't identified what that crucial evidence was. She faults Judge Martin for not wanting to wade through a 728-page document that consisted of text messages between the parties over a period of several months, with many enlightening texts like, "I took Sport for a walk this morning." That's not a trial judge's job.
No, they shouldn't be walking Sport.
And rather than relying solely upon the AKC ownership, which Judge Stargell pointed out, only Dr. Miller could have obtained for herself as the owner of the mothers of the dogs, instead of relying solely upon that. She looked at the communications and the conduct of course of dealings between the parties and determined that the original agreement had been for co-ownership, and that when there was a falling out between the parties, Dr. Miller wanted to renege, which was not allowable. What Dr. Miller needed to do was to point out findings of fact that were not supported by competent and substantial evidence, which is what she failed to do. I have little to add that was not in my brief, so if you have any questions for me.
There's one question. All right, thank you.
Thank you. One thing that I would like to point out is that the transcript,
I gotta start your time back up, sorry.
that's
You're
fine.
down to 17 minutes and 54 seconds.
I think I can squeeze it in. The transcript is 127 pages of Dr. Miller's testimony and a little more than 60 pages of appellant or appellee amends testimony. She had more than twice as much time as the defendant had in the case, and she called 5 witnesses. She got a full hearing.
Again, the issue is not necessarily how much time she had to testify or not testify. Ms. Amends has 60 pages of what was stated was 60 pages of testimony and
My recollection is that the record in this case reflected that that was the amount of time, that the judge said this is the amount of time, is that sufficient? And both sides said, yes, that's sufficient.
And again, the issue is not so much was the time sufficient, but how did it break down?
The
And
judge
when-
kept pointing them and saying relevant evidence. He was looking for things that were relevant, wanting to hear what the core of your argument was that rebutted the concept that she picked up the dogs and had them in her custody and why they should be given back to you. And I agree with you. Several times he interrupted when the judge felt like it was going down a rabbit trail that wasn't leading to relevant evidence. Again, he didn't say you can't present this evidence. He was trying to, from the record, it appears, get your client back on track to get the information that he was looking for. So why should we fault him for saying this isn't something that's helping me, so I'm going to help you by pointing you in a different direction?
Well, first of all, the judge in the lower court, the interruptions were not precipitated by an objection from the other side. It was not precipitated by any
It's
issues.
the finer fact, and it's just like in a divorce case. When you're listening as a trial judge, and we've all three of us been trial judges. You have to make the decision, and so you want evidence that's going to help you make that decision. And if you keep hearing the same thing over and over again, then it's not going to be terribly helpful to make that decision. Then a judge will typically step in and say, let's move on, this isn't terribly helpful. And I just don't know that, again, how we write an opinion that reverses a trial judge for doing that. I'm not unsympathetic to your client's position. This is not the traditional agreement for wealth services. There's typically a fee, and then there's a, weekly, charge, and that is typically how it occurs, except here, there was nothing typical about this relationship. And I keep going back to the texts and emails, and what are we supposed to do with those? Do we just ignore those?
No, Your Honor, if I also may add that some of those texts and emails in September, actually, there was an objection that they were settlements emails, that they were an attempt to settle prior to filing a lawsuit. And
Well,
that
the
what
trial judge found it's clearly not a settlement offer. It's her saying this was our deal. The whelping deal was co-owned or get paid, not your choice, mine. I can't co-own with you, so I will pay what was agreed. That wasn't sent in the settlement offer context. That was sent to say, this is a summary of what our deal was. I can't do the other, so this is what I'm going to do. But this was long after she had given custody of the dogs So it seems she wanted to keep strings attached to decide whenever in the future. The trial judge looked at all the evidence and said, no, I'm not going to grant you replevin. So why should we now overturn that judge and say, return the dogs? He didn't say that your client doesn't have the rights. I mean, she still co-owns and they're gonna have to work that out. I think he even suggested mediation or however they're gonna work that out, but why should we return that when the judge already made that decision?
Because the case law, and I'm out of time.
No, keep going. We've got
Okay.
Plenty of time.
Because the issues with how the trial was conducted, both the temporary possession on which there was a large amount of reliance on that hearing, and and a hearing that was not completed because the cross-examination was not completed of the defendant or appellee. And so
Right,
the
and
case law.
And Eppley makes the point that there was no profit made of that evidence. And I'm sure that you are well aware of the fact that if you're going to make an argument that we weren't allowed to present, certain evidence, that you have to make a profit of that evidence for it to be preserved for purposes of appeal, because that allows us to analyze whether, the evidence would have been admissible, whether it was relevant. So was there a proffer made of what you weren't allowed to present?
Yes, Your Honor, actually there was.
All right, what was
And
it?
that proffer was information on the appellant's breeding program. And the reason that was important was, and again, that's in the very beginning, that it was being represented and she was cut off while she was trying to represent information on her breeding program, which showed, or would have shown, and this is what I believe is in the record, or would have shown not only why these dogs were important, but why these dogs were supposed to be hers and part of her breeding program.
What page in the record was that proffer?
Your Honor, I would have to see the transcript, but I know it was proffered during the time that she was
Was it in
being
your brief?
cut off. It isn't, I believe it's in my brief. That when, I believe it's in the brief, but it would have been in the transcript and it would have
It's not
been,
even, it certainly isn't listed as an issue on appeal that you've raised. You did talk about being interrupted, but that's fine, that's fine. Anything else that you'd like to add?
simply that the cases that were presented by the appellee, sorry, the two cases that are not Florida cases about the registrations,
The AKC.
the AKC certificates of registration, that those cases are actually, the Dubin case is very similar to this case, and they found in both of the cases represented by the appellee, that both cases, Budowich and Dubin, that the court found actually for the registrants.
All right. Thank you very much for your presentation. All right, do you want to move right in, or do we need to wait till, let's see what the time, it's set for 9 as well, so I think we can move directly into the next case. Thank you both. All right, the next case on the docket. We have is Nieves versus State 2321. I know that that's going to be a tough oral argument to follow up on, but I want you all to just do the best you can.
Good morning. May it please the court. My name is William Pennell and I represent Miguel Nieves, the appellant in this case. Please reserve 5 minutes of my time for rebuttal. This court should reverse Mr. Nieves' convictions for the 2 reasons stated in the briefs. Because trial counsel provided ineffective assistance of counsel by failing to object to an erroneous jury instruction on burglary and by failing to object to inadmissible hearsay testimony that indicated or implied that Mr. Nieves had committed prior burglaries against the same victim in this case.
Right now, as to the first, I don't think there's really any challenge that constituted ineffective assistance. The issue in that was prejudice, and the trial judge relied upon in part self-full entry. So and your brief didn't really talk that much about the facts of the case that the judge relied upon to make a finding that there was no prejudice. So perhaps you should address that.
Sure. Well, first of all, the Grant case says that just because there may have been stealthy entry does not mean that the erroneous instruction is not prejudicial to the defendant. There still has to be, it's a permissible inference. The jury may infer intent to commit an offense, but is not required to. They still must find that there was intent to commit an offense at the time of entry. It's our position that here, all the evidence concerning intent was circumstantial. There was certainly no evidence of Mr. Nieves leaving the home or holding any property. He wasn't seen holding any property. He wasn't seen attempting to gain access to any property. They certainly no property of the neighbor was found on his person or in a search of his home. So the evidence concerning his intent was circumstantial. So the prejudice that was discussed in Grant, where you have this danger of a circular reasoning where the jury may find him guilty based solely on the fact that he committed trespassing, which his attorney actually conceded and asked the jury specifically to find him guilty of.
So he's got some sort of hat, which I don't think he was wearing, but apparently the argument is that he was concealing something, although we don't know what, do we?
We do not. The evidence is that the victim, Rachel Osteen, said he was holding a hat and it looked like there was something underneath the hat. We have no idea what it was, and there's no evidence in the record one way or the other whether there was something under the hat or what, if there was, what it was.
In terms of the evidence that wasn't objected to, the trial judge, I think, ultimately concluded that it was strategic. Would you address that?
Sure. In 2 different places in the record, the trial attorney said she had no idea why she didn't object. And I think that's pages 516 to 17 of the record and 531 to 532 of the record. She said, quote, "I have no notes or memory of why I did not object to the hearsay testimony."
Okay, so her later testimony, do you read that testimony as trying to rationalize what occurred?
It appears so, and I would suggest even if there was some strategic reason in this case, I would cite the court to the Bowers decision where it says if there's a strategy that's employed in an unreasonable manner, it's still ineffective assistance. So even if we have a strategy here, I think her implication was she potentially didn't object because she hoped to make an argument about him having a key in closing argument, but then really didn't do so. And our position would be the way the question was asked and the answer to the testimony goes beyond him just having a key or not having a key. The answer certainly suggests that there was previous burglaries and implies that Mr. Nieves was involved in the burglaries.
But
So
counsel, isn't that very different than the other case? Because I think you just characterized the way the jury could have taken that testimony, and that is what the witness said was that the victim thought that your client had committed a prior burglary because he may have gotten a key because he worked at Lowe's. Is that a fair characterization?
Yes.
That's very different, isn't it, than hearsay where someone says, a child, for example, in some of your cases, talks to the CPI and CPI says the child told me that someone committed a sexual crime on him. That clearly is evidence of a prior crime. Isn't that very different than the testimony here?
I think I can see that it's more prejudicial in the hypothetical, but I think it's prejudicial in this case as well. Especially when you're on trial for burglary, and now that they're talking about other burglaries in the neighborhood and casting doubt on, implying to the jury that he made a key and had previously broken into the same home. So again, I agree with you that it might be more prejudicial, but I think it still meets the prejudice prong of Strickland in this case.
But doesn't there have to be a reasonable probability that the jury would have received that evidence and instead of taking it for what it says is the victim thinks he committed a prior burglary, to actually conclude, oh, he committed a prior burglary?
Well, I mean, I guess there's no dispute in this case that there was that someone tore the screen and someone did these things, and apparently she had been the victim of prior burglaries. So I don't think there's any reason to disbelieve. I think the jury was likely to find Miss Osteen a credible witness. I don't think she was impeached in any regard, and I don't even think anyone was seeking to impeach her, because the sole argument was, did Mr. Nieves have the intent to commit an offense inside the home? And as the court knows, a reasonable probability under Strickland is just a probability sufficient to undermine confidence in the outcome. It doesn't even have to rise to preponderance of the evidence. So, and even in case.
Let me ask you on that, in the Harrington case, citing Strickland, they quote, it says, this does not require showing the counsel's action more likely than not alter the outcome, but the difference between Strickland's prejudice standard and a more probable than not standard is slight and matters in only the rarest of cases.
Sure. I think it's still important to remember that even if the court were to agree with the state that there was strong evidence of guilt, both the Romero and the Botto case say that does not defeat prejudice if the defense theory could have, if believed by the jury, could have led to a not guilty. So if the jury believed Mr. Nieves' statements to the police that he observed someone in Miss Osteen's yard and went over there to check on it because he was worried that someone was, messing with his neighbor's home. So I think we have, if the jury believed that, that's a viable theory.
Well, the jury apparently didn't believe it.
Well, we don't know whether they believed it because they got the instruction that allowed them to find Mr. Nieves guilty based solely on his trespass. So the only way
they
to
were
know.
Instructed that they could find him if there was an omission of the exclusion of trespass.
There was, and the Supreme Court in 2013 modified the standard instruction. Several courts, based on numerous courts saying that the instruction without that additional language was confusing. There was several cases prior to the trial in this case that suggested that. And the Grant case talks about the danger of the circular logic and says omitting this portion of the standard instruction allows the jury to find a defendant guilty based on the circular logic the defendant was guilty of burglary because he entered the structure with intent to commit a burglary. So here we have the same issue. The omission of that language in two different spots allowed the jury to find Mr. Nieves guilty based solely on his admitted trespass. And
That's only if jurors engage in circular logic and maybe judges or lawyers apparently.
well, I think the case law, I mean, the courts have said that the instruction without that requires circular logic. And then the cases say that we assume,
Counsel, the cases that you cited prior to Grant, in that case, the judges actually added the language that directed the jury to engage in circular logic, right? But they added the language about burglary, isn't that correct?
in some of the cases, yes, but in the Grant case, they left out the burglary instruction that was supposed to be in there, the intent, so that's the most similar case to what we have. And there was the case that was argued most strongly at the evidentiary hearing, case that was considered most strongly by the trial judge. I think this is the case that this court should look at as the one that controls this case.
Do you have was there a case, I didn't find one, but maybe I overlooked it. Was there a case where, other than Grant, where the jury was not specifically directed, they could not base a conviction on the offense being burglary or trespass before Grant? And really, quite frankly, before the amendment of the 2013 jury instructions, because I looked as to why that happened, I couldn't find a case where that was found to be reversible error on appeal. That is, the failure to use language in the jury instruction in the 2013 version, that was found reversible error, to not include it.
The only cases I'm aware of, there are ones where they use the language burglary, intent to commit burglary. I'm not aware of any cases. I'm also not aware of any cases that said it was not reversible error either way. So I don't know that we have a reported opinion either way on that issue.
Well, apparently, if the Supreme Court was unconcerned with jurors using circular logic, there would have been no need to amend the jury instruction, would there have been?
Correct. So what I think is important to know is, in response to your question, Judge White, as lawyers versus laypersons on the jury, the law is clear that the law presumes that the jury followed the trial judge's instructions and the law that they're given. If you read the closing argument, both the state and the defense repeatedly tell the jury to rely on the instructions that have been orally read to them, or going to be orally read to them, and that are being given to them in writing. The Grant case and the cases before that, and the Florida Supreme Court have concluded that this logic is circular. I don't think we can substitute our knowledge and decide that the instruction is not circular and assume that the jury somehow disregarded the circular instruction and found the right result. There's no evidence in the record, and now we're speculating. I think the law is it's circular, and I think Mr. Nieves was prejudiced.
Well, when you say the Florida Supreme Court, you're talking about the decision adopting the jury instruction where it specifically says, by adopting this, we're not saying it's correct, or it's the law.
Sure. And then Grant went on to say why it was done and cited a bunch of cases that I think support the decision to amend it. And all the cases that reversed because it said intent to commit burglary was insufficient, I think support this amendment and makes it clear to the jury that you cannot rely on intent to commit trespassing or intent to commit burglary. And Mr. Nieves was prejudiced in this case because of the circular logic and based on the absence of direct evidence that he intended to commit an offense inside the home. Again, we would be in a completely different position if Miss Osteen walked down into the kitchen and Mr. Nieves had a handful of her property, or he was walking out with her property, or they searched his home and they found his property. We don't have any of that.
Yeah, but you do have the presumption. You have the presumption based on stealthful entry.
And again, the Grant case says that that's not sufficient. The jury still, the state still has to prove an intent, and it's a permissible inference. It's a permissible presumption. And the Grant case explicitly says that's not enough to remove the prejudice of the confusing and circular instruction.
Well, the Grant case wasn't governed by the Strickland standard either, correct?
It was not, but it is not. But again, the Strickland standard is just, do you have confidence in the outcome? And I suggest the court cannot have confidence in the outcome of this trial, given the circular instruction, given the circumstantial evidence of intent, and given the comment about the potential prior burglaries by Mr. Nieves. So we'd ask the court to reverse on those bases, and I reserve the rest of my time for rebuttal.
All right, thank you, sir.
Good morning. May it please the court, counsel, Wayne Goff on behalf of the appellee, the state of Florida. It's the state's position that the appellant has failed to establish the requisite prejudice that specifically.
Well, let's start with, you know, some basics. You agree that this lawyer provided ineffective assistance of counsel in terms of the jury instruction, correct?
Deficient performance, but not prejudice. The whole
Ineffective assistance of counsel.
ineffective, why I believe that is two parts prong.
Right.
Where the ultimate conclusion is ineffective assistance of counsel.
Was it effective assistance of counsel to not get a jury instruction that encompassed the theory of the defense?
It was a deficient performance to not object to this jury instruction.
Well, that we can, I don't want to spend 20 minutes debating the nomenclature. Do you agree that the failure to object was deficient?
Yes,
Okay. So really all we're talking about is the prejudice.
right. And we're not contesting that the jury instruction was not the standard jury instruction.
Do you agree that when the trial court makes a finding that this was strategic, that on this record cannot be supported?
The strategic decision to not
Not
object?
object.
No, it wasn't a strategic decision.
So the trial court's finding that it was strategic was wrong legally.
I'm not, I wasn't aware that he found it strategic. I think in terms of not objecting to the jury instruction, he said it was a deficient performance for her not to object, and she should have been abreast of the law at the time. That's my understanding of his order.
What is more fundamental than not giving a jury the correct jury instruction, particularly when it is the essence of the theory of the defense?
Well, I agree with you that the case law says that standard jury instruction should be followed, but absent an objection, it's not per se fundamental error. And I cite to State v. Bryan, where
Right, and that's why they couldn't raise this on appeal. That's why they couldn't do it on direct appeal. They probably can't do it on ineffective assistance of appellate counsel because it wasn't preserved by the lawyer who apparently was not as sharpest, at least on this day, in terms of the representation of Mr. Nieves.
well,
Here, you got a lawyer that ends up making an argument to the jury, and there's absolutely no jury instruction that supports it. Now, what is the jury going to pay more attention to? The lawyer's argument or the judge's jury instruction?
I can't get in the mind of the jury. I'm sure there's some circumstances where they're going to focus on the trial court. I'm sorry.
I've tried a lot of cases, and I'm telling you that they look to what the judge tells them in terms of the jury instructions, because that's what the judge tells them to do. Says what the lawyers say, isn't evidence, nor is it the law. The evidence came during the course of the trial, and I'm going to tell you what the law is, right? Isn't that what the judge tells the jury?
That is correct, yeah.
Okay. And here, so you end up having a lawyer that gets up to give a closing argument and makes an argument why, this shouldn't be a burglary because it's just a trespass, with zero jury instruction to support that theory of the defense.
Well, I want to clarify, the record indicates this is a attorney with 30 years experience, very accomplished. This is not a newbie.
Doesn't matter whether it
I
was
understand.
a day, a year, or 30 years, we've already established and you've already acknowledged that for purposes of this case, this lawyer performance was deficient, not just on one ground, but on two very important grounds.
But, okay, I'm just addressing the jury instruction. I do argue in if you're talking about the second issue, I do believe that that was a strategic decision.
Oh, no, I just asked you that. I thought we.
Oh, I
Yeah.
apologize, Your Honor. I'm confused.
All right.
The
well, good.
second, I
Let's-
believe
Let's go back and talk about it then.
okay, all right.
How can it possibly be a strategic error when the lawyer at the evidentiary hearing says, when asked, why didn't you object to this? Says, I don't know. How can that be strategic when you don't know why you didn't object? I mean, it appeared to me from reading this that everything that occurred after that is just a rationalization of well, now this bad stuff came in and how am I best going to deal with it? And that's what she did. She dealt with it the best she could deal with it. But when asked twice during that hearing, why didn't you object? Her answer was, I don't know. You can't have it both ways. You can't say it's strategic when you had no understanding of why you didn't object, correct?
That's correct.
Okay,
We're-
so now we've established that that's deficient performance and it wasn't strategic.
Well, I guess looking at it in hindsight, years later, if she didn't have notes
That's
or
what we
doesn't
do.
know off the
That's
top.
what we
of her-
do. That's what we
Right,
get back.
correct. And so,
Counsel,
okay,
doesn't the case law state that the subjective intention of counsel doesn't matter, that it's an objective standard? The Florida Supreme Court in Patrick said that counsel's inability to recall was irrelevant. Isn't that correct?
yes, Your Honor, that's correct. And that is what the trial court's order kind of looks at it objectively and says that drawing attention to this by objecting to it, and it's the state's position, this is a spontaneous statement by this officer that he didn't have to include that there was a burglary in that statement.
Well,
then
you
draw-
can't have a strategic decision that you're completely unaware of. I mean, I just don't see that. Why don't you explain to me how you can have a strategic decision that's a conscious plan and be unaware of it?
I think based on her testimony, I understand it, and I'm kind of going in and out of the objective versus subjective. So she's saying in the hearing years later that I don't know why I did. Obviously, there's no notes that indicate to her why she did that. This lady is probably doing several 50 trials since that time. And
This is collateral, what comes in is collateral crime evidence. I mean, and the law, is that's almost presumptively harmful.
well, she objected to, she was able to prevent through her, her lawyering that he was a suspect in that burglary.
Oh, please, let me read this to you. Do you recall if Mr. Osteen mentioned you any, Miss Osteen mentioned to you any concern she may have had about Mr. Nieves having worked at Lowe's and possibly having made a key to her house? And then the guy goes on to say, yes, because she had these prior burglaries. You think it takes a rocket scientist to link the two of those together and to draw the arrow pointing directly at Nieves as the perpetrator of the prior burglaries?
Well, what I'll say is,
What would be the relevancy of it otherwise?
and I understand that, and then it came out, and so we're talking about whether or not that was enough prejudice to undermine the confidence of the outcome or that,
You
but
agree
for the.
when that came out, that points the finger at Nieves as the person that committed the prior burglaries.
Well, what I'll say is that trial counsel testified that her defense was to blame Franklin Hooks, another person, for these crimes. So if it comes out that there were prior burglaries, that feeds into her defense. It makes it stronger. And that's what she argued in closing
That's
argument.
what she's arguing. I don't, but what I'm suggesting to you is, isn't the point that the only reason that comes in is to point the finger at Nieves? Otherwise, it's absolutely irrelevant.
Yes, the actual testimony is objectionable and should have been sustained if it were objected to. Unfortunately, we're talking about it hindsight now. And we're talking about whether or not that was deficient performance for her in her trial strategy to blame Franklin Hooks and say, but I also,
A trial strategy is a conscious decision.
right. Objection, objective standard, I'm sorry, as Judge White pointed out. So when the trial court said, or in its order said that it would highlight it, there is a strategic decision to that in an objective standard. That's all we're saying. And this court can disagree with me, but that's what I'm saying, in an objective standard. And I want to also highlight the differences between in issue 1 in the Grant case. And I really want to emphasize that in that case, you have a lawyer that is, and the judge going back and forth. The lawyer is explicitly asking for this instruction. The judge is saying, I don't agree with the standard instruction, goes against it and explicitly doesn't follow the judicial procedure for going against that. That is not what we have in this
I
case.
know. Weren't there 3 people in that courtroom that should have known better on this jury instruction? The defense lawyer, the prosecutor, and the judge all. This wasn't a jury instruction that was passed a week before this trial. In my recollection, it was about 3 years before this trial. What's going on with that?
Completely agree with you. The instruction was not the standard jury instruction. And
And it was the theory of the defense.
well, that it was a crime other than trespass. She is faced with this conundrum of, she has a credible witness giving direct testimony that this is a trespass to this jury. She is saying, this guy was in my house and he did not have permission. She has to make a decision in this case of, do I concede this trespass? I cannot get up to this jury and credibly argue that the trespass wasn't proven.
Wasn't all. But how far the unit is there, how the unit is there, how there is this appearance.
Yes, and he was aware of the schedule, asked them about the schedule. It was just during work hours, the cars weren't there.
Did you know the schedule of the roommates? Did he ask about that?
From my memory, the testimony was I just remember he asked about what their work schedules were. That's all I can remember. I don't want to misrepresent what the record indicates. That day was unusual where she was dropped off by one of the roommates because her car was at someone else's residence. The screen was slashed from roof to the floor, or I'm sorry, big enough for a person to fit through. The screen patio door was locked. It was still locked.
Was he seen with any cutting implements?
No, but as you mentioned before, he has a cap or mask, whatever the jury decided.
thought it was.
The victim testified it was it looked like a mask, and what was found on him was not a mask. That's where we're at with that and the evidence. But she was holding something that looked like a mask. A knit cap, yeah. Yes. And I think she testified something that didn't match the weather wise, like that in Florida, I guess at that time. That's just my memory.
Hoodies aren't real comfortable.
Right,
for you.
right, exactly. And that there was something wrapped in the mask, and you have the screen was cut, and she says it wasn't cut before.
Really? What did she say was wrapped?
She didn't say it. I can't take that leap, but the jury can infer this from the evidence that this was stealthy entry and that they can presume that a crime.
Locate any kind of cutting implement in his house that was consistent with the screen being cut?
That was not in the record, Your Honor. That was not in the record. They found the cap. But there were pry marks on the French door, which leads into counsel's strategy, is that there was some evidence that he might have had a key. Why would he pry the French doors open if he had a key? This led to her, this is kind of the only avenue she can go with this type of evidence, with all this stealthy entry evidence. There's a ton of it. And his explanation is illogical, that he's just doing a welfare check on them. Because his actions afterwards also don't indicate that he saw somebody else, another character coming in the house. She saw him leaving the back, and a thud, she heard a thud. It was, all of that evidence is why stealthy entry is in there. This is a clear stealthy entry type burglary case. And Grant, in that case also, they're looking at it from whether or not the trial judge doing that was harmless error, which is a different burden, which is a different standard than this prejudicial standard. I think the appellant wants you to take a leap that because it was omitted, they explicitly or specifically found him guilty because he committed a trespass, but that's illogical.
And how do we know they didn't?
There's no indication in the record that they did, and under this standard, because it's illogical.
But listen, that argument that it's illogical, that's, yeah. If it's so illogical, then the Supreme Court must have been real fools to have bothered amending this in the jury instruction. It's so illogical that they felt a need to add this language into the standard jury instructions. So I'm not sure that, at least for my part, that I'm going to buy it's illogical. A jury could find that the entry of into a house for purposes of committing a trespass with no jury instruction to the contrary constitutes a burglary. That's the problem. That's the whole reason for the amendment to this instruction. And to argue that, well, that's, illogical, that a jury would never do that, just flies in the face of what the Supreme Court did and says to me, well, Supreme Court, you didn't need to do that. It's illogical. No one would do that. No one would find that this could constitute a trespass or a burglary. If the same thing holds true for that, although I can give you a hypothetical where you actually can't commit a burglary. You want to hear my hypothetical? You go into a house, you go into a garage, part of the structure, and there's a car in the garage, and your intent is to go into the car and steal things out of the car, which is a burglary of the car. So I'm just giving you a hypothetical where you actually could commit a burglary with the intent to commit a burglary in there.
But,
So counsel, I guess in response to
We're getting a little off.
my esteemed colleague, but unless, and Mr. Pinal hasn't argued that this is the rarest of cases. And so since the difference between more likely and not is only slight, other than what you've already argued, why would you suggest that it's not a reasonable probability that there was prejudice, other than the fact that most members of the jury don't have my colleagues' 30 years of experience as a lawyer and a judge and a practitioner?
That makes me younger than I am. Thank you.
well, and I'm going to point back that the burden is on him to show that there was some sort of prejudicial outcome. I don't believe there were any jury questions that came back that indicate that. The counsel.
Was there any argument by the state, despite clearly the instruction didn't direct the jury to engage in the circular reasoning that the appellant is saying was a danger? Did the state argue saying he admitted to trespass, ladies and gentlemen, we're done here?
Right.
In fact, I don't even know why we're here. If it's all about trespass, go ahead. By finding him guilty here, this concession, you can automatically, it's going to be a real quick time in the jury room. Did they argue that?
And that's a simple no. The state, the judge, nobody told this jury to convict him based on the crime intended to be committed with burglary or trespass. So they were not informed that they could do that. Nobody told them they should do that. They were told that a crime needed to be committed.
Anybody tell them they can't do that?
Well, no, that's true. But the defense counsel's argument to the jury that conceding the trespass, when a lawyer does that, you are pointing out the differences between burglary and trespass, and that is that intent of the crime to be committed therein, and therefore the jury. The record does not indicate that there was any prejudice, or that they convicted him based on that. So if this court has no further questions, I would ask that you affirm the post-conviction court's denial of his 3850 motion. Thank you very much.
It please the court. First, as a factual issue, my understanding of the record is that the only information that the testimony established was that Mr. Nieves knew Miss Osteen's schedule. There was no evidence regarding the 3 other roommates. So I don't know if there's evidence that he knew that the house was vacant. I think that argument's not supported by the record. In addition to the judge telling the juror members that what the attorney says is not the law and is not evidence, the attorneys, both the prosecutor and the defense lawyer, pointed it out to the instructions, told the jury to follow the instructions given by the judge multiple times. The sole defense was intent, and the judge, the defense lawyer asked the jury to find him guilty of trespass, which is what I think the judge said was a strategic reason. And I agree under the facts that made sense, but that doesn't make it reasonable not to object to the instruction that allows them to convict him of burglary based on the trespass. The Grant
But
case.
is it reasonably probable that this jury, with the defense counsel conceding, almost implicitly requesting the jury to find the client of the lesser included, which, since your client was PRR, was significant. That was a good strategy, don't you think?
Sure, under the facts of this case, yes.
And so that's what I'm struggling with, counsel, is how reasonably likely is a group of our citizens are going to be in that jury room if they believed him. Say, guy committed a trespass. It's conceded it, and look at the jury instruction. Yeah, for some reason, this is a higher offense because they were instructed on what a lesser included offense meant, right?
The law is, there's no dispute about this. The juries, we presume the jury follows the instructions. The law says the instructions circulate. If you look at the Smith case, the court misread a portion of the standard instruction on self-defense, telling the jury that the appellant was justified in using non-deadly force, then it should find him guilty.
Let's not talk about self-defense. I agree. We could be here all day if we talk about that stuff. But in terms of the burglary instruction, the jury, and I agree, we must presume the jury followed the law. They were directed to find your client had the intent to commit an offense. So the question is it reasonably probable that offense, because they returned a verdict of guilty, so assuming they followed well, they had to find there was an intent to commit some offense, that offense, is it reasonably probable, was burglary or trespass, as opposed to theft or something more nefarious, given all of the evidence in the case, including his inconsistent testimony, mentioning to law enforcement, and his testimony is what he said to the victim being very different. For example, the young black male, the victim, he just mentioned someone, doesn't identify the race. He saw a cut screen door was unlocked. That was inconsistent. He doesn't call the police, even though his wife lives right next door. He then goes to Tampa.
I'm not sure why.
Isn't it a virtual certainty that if they believed your client, they would have found him guilty of trespass and that's it?
No, and I don't understand why he would call the police when the owner of the home knows that the place has been burglarized. Why he wouldn't call the police? I mean, she's on notice what happened. She can call the police. I don't know. It doesn't make logical sense why he would call the police when he went over there, if we believe him, he went over there to alert her to find out what's going on. But she kicks him out of the house because she's upset with him. Why wouldn't she call the police? Why would he call the police? It doesn't make logical sense to me.
If he did not. Solve something with the fact that it was in place.
Sure.
Not the work was not there. Why would an advocate call?
No, right. If you didn't have, if you didn't have the encounter with the owner, I agree, you should have called the police. But once, well, I think he's trying to find out if everything's okay.
Or you say, I'm gonna take it on myself, go in and see what's going on here, I call the police, because otherwise you're gonna be fined, whether it's trespass or burglary, you've entered the structure.
Well, then made that, everybody agrees that that was a poor choice, that he trespassed, like,
Going back to your other, start off with. Find it about the roommates, the website, on the record. Trying to get them to see, trying to use the work schedule, use the work during the day. And that if someone was home, you get to the picture and park outside, not bring that to the record.
my memory of the record was that it was, the specific schedule was only about, the one individual, but if I'm wrong, I stand corrected. The only other thing I would add is in the Long case, the first DCA found that this instruction or an instruction similar to this, where intent is an issue, is so serious it can rise to the level of fundamental error. So to suggest that where it's the sole defense and there's no direct evidence of intent, that he wasn't prejudiced, I think it's just not supported by the record of the case law. So I'd ask the court to reverse.
Thanks. All right, well argued on both sides. All right, the last case for the morning, Hester versus Becker et al., 23-382. Or y'all might not have been here when I made some opening remarks, but if you'd like anything less than 5 minutes for rebuttal, just let me know. We'd be glad to accommodate you, and if either of you have any electronic devices, if you just make sure they're on silent. Okay, whenever you're ready.
Good afternoon, or excuse me, morning still. But please the court. My name is Brian Lee. I represent the appellant in this case. And 5 minutes is perfectly fine for rebuttal. Thank you. This case comes to the court from a summary judgment that was entered by the trial court, where the trial court determined, and it seems by looking at a video, that the sole and independent cause of a collision between my client, Mr. Hester, and Mr. Becker in the truck was caused by Mr. Hester. And therefore, because the trial court found that Mr. Hester was the sole and independent cause of that, granted summary judgment. There are two issues with that. There are two, I call them baskets of evidence, that the trial court had in front of it that put evidence into the record that a jury could have used to find negligence on the part of Mr. Becker. There's speed, and then and there's conflicting evidence, obviously, on that. They presented an expert affidavit that conflicted about that. And then there's also evidence from a human factors expert about perception time. Yes.
The affidavits that your experts patent, did they offer opinions based on a reasonable degree of scientific certainty?
They don't list that in there. It doesn't actually say in the affidavit.
So are we supposed to assume it?
Well, I think we are supposed to look at what the trial court based his opinion upon. The trial court did not say in his order, or frankly at the hearing, or at any part of the record, that, well, I'm not
reviewing these experts' opinions, because I don't believe they were within a reasonable degree of scientific probability or whatever it is. So there is no indication that the trial court rejected those affidavits. Actually, there's no indication that trial court rejected them at all for any kind of technical reason. So that is, I don't believe that is an issue that this court has, because there's no indication the trial court did that. What the issue is
Wouldn't
that
it be an issue under Tipsy Code?
I don't believe it would, Judge, and because number one, the appellee never brought that as a claim in this case. Appellee has not said, at least unless I'm missing something in the briefing, is that, well, we think the trial court still, even though the ruling was wrong, we think that it's because of this. That's not brought as a doctrine in this case, and for the court to adopt a doctrine that the appellee themselves didn't do, I believe would be error. And so
Even if it's on the face of the record?
Even if it's on the face, right? Yes, I would, because of the fact that this court would have to be saying to do that the affidavits, just from the standpoint of evidence for summary judgment, were not proper evidence for the court to consider at a summary judgment phase. There's nothing in the law that I know of. Obviously, there's lots of law that talks about when you get to trial, you have to say, hey, look, typically that's sort of the buzzwords, right? Reasonable degree of medical probability, reasonable degree of scientific probability. But there are cases, and we didn't go into this because that wasn't part of the argument, but there are cases that say that you don't have to have magic words to do that.
Well, let's talk about obviously we have the new summary judgment standard.
We did.
And that's applicable to this case. There is no criticism of the trial judge for reviewing the video, is there?
No.
Okay. And didn't your human factors expert, correct me if I get this wrong, but I thought it was like something like 3.1 to 3.4 seconds in order to
Reaction time.
Right, reaction time.
Right.
So can't the trial judge look at that video and see where the bicyclist, and I can't say that 10 times fast, gets past the cars that are in the left-hand turn lane waiting to go, and comes into view with the car going straight, and look at it and say, well, that's less than 3.1 to 3.4 seconds. Is there anything wrong with the trial judge making that determination? Apparently the judge watched this video a number of times, and I'm going to tell you, yes, did I.
Yes, I think there is an issue with that, because we're not talking about when, two things. There was evidence that was shown that would rebut what the driver said. Meaning when the driver said he percepted my client or the bicyclist in this scenario, there's evidence that rebuts that because of and it's from the video too. The expert talked about and it was discussed that there was this sort of braking maneuver that was done, at least from the view of the video, that was done by plaintiff's counsel. Expert talked about it and said that because of that, and because of the analysis that was done at the scene, that was 5 seconds before.
Didn't they see the cameras up high?
Right. On to the side, as well as to the side, sort of like a,
But
yeah.
it's, I'm higher, I can see things here that you wouldn't be able to see from your desk.
Sure.
Thing from the video was different, that you think you could see it from the camera, but prior to see it. The camera seems to be a good 10 or 20 feet higher than the driver would be on the road.
Right, but you're,
5 seconds, I can try to find it and see when 5 seconds that it, or basically would have been outside of the screen.
well, and one of the things I think that's important to note is that this video, not the greatest video, right? And it's from a side, and it's also what the testimony was, which I don't think was rebutted, was it's 30 frames per second. Okay, and so it's not a sort of real time, kind of as we're all used to it. You see the whole thing and it's just clean like that. There's sort of jump right in the video. And so what they had to do was the experts had to go to the scene, which they did, both of them did. They went to the scene, they picked out landmarks. I think it was the tree landmark that they did. They saw the distance, they saw the video, they saw when the trucks were there. And so they could extrapolate from that, which is what accident reconstructionist does, how much distance are there. And then when they get the distance between there, then they can talk about how many seconds does it cost. I mean, that's. There were.
How would they know exactly when the driver was focused on the road in front of them? That he didn't, that he should have had that 5 seconds.
Well, it's part of it is the analysis they did of the scene, which they always do, analysis of the scene. Second of all, too, is because of the fact that at least the experts are saying, and Plans Council talked about that there was a braking maneuver prior to right there. Prior to you see Mr. Hester come out, and then the truck's coming, and it's sort of like kind of in the middle of the truck where you see the impact. The experts talk about that the video does show braking maneuvers happening in an area that would be 5 seconds before.
But is that proper expert
Or
testimony?
before.
Because that sounds to me like an expert saying, here's what I see from the video. Which you don't need an expert to tell a jury. I looked at the video and this shows the defendant, shooting the victim.
But yeah, but what you can do as an expert is you could say that this is the distance. This is the reaction time. These are the set, if it's, I think it's 0.23, it's like a fourth of a second. And this collision does not happen. And the expert can say that he had time, the driver, to stop prior to hitting the bicyclist.
But
An
what I
expert
mean
can
is,
say that.
that all starts from the premise of, I see a braking maneuver. That's a fact, isn't it? That's not an opinion.
Well, it's,
Based on
I don't
the view of
believe-
the video. I mean, that can only come from the video.
Sure.
Or unless it's totally a baseless opinion, right?
no, I understand that, but experts can talk about facts.
They
That
can
are-
talk about facts. But
Correct.
they can't put their expert stamp of approval on something that the jury is. Can they?
I agree. They cannot talk, what an expert, I'm trying to answer your question. What an expert cannot do is an expert cannot say definitively. Expert can't put all those facts together and then say, and jury, he should have, and jury, his perception time was terrible and that therefore he was negligent. Because the expert can't do that. The expert can't tell the jury that because of all these things that I've done and all the seconds and everything, then that means that that person was negligent under the law, the defendant in this case, nor could the plaintiff, the defendant do the same thing to the plaintiff, but the jury could have been given those facts, right, from the expert and determined for themselves, looked at it, saw, okay, I think I do see it. And that expert said that was 5 seconds and that would have been enough time to move. So I'm going to put negligence on that driver. And then mind you, what we're talking about here is not a situation, number one, that we're at trial and the jury's making that decision, right? But number two, that we don't need to show definitively a summary judgment hearing that the jury will absolutely say that the defendant was negligent. All we have to show is evidence that the jury can reasonably use to do that.
So it's your burden under the new standard, right? Just like a directed verdict. You have to
Right.
present sufficient competent substantial evidence,
Mhm.
if believed, would allow the jury to find for your client on all the elements of the offense, correct?
Right, very, very similar to the directed verdict standard.
Okay.
Right.
And so tell me from the summary judgment evidence. Let's move past my first question. So let's assume that this is an opinion. And that is, if you members of the jury find that you agree, you see a braking maneuver at this spot.
Mhm.
Where in the summary judgment evidence does it tell the jury where that spot is?
The summary judgment evidence is the expert does.
But
The expert
but
says
where?
when that was done, that's 5 seconds before. And so
What I
and it's
mean
a
is-
3 to 3.3 perception time. The expert says that with normal perception time, that driver would have been able to see it or see Mr. Hester, hit the brakes, and Mr. Hester would have had enough time to have basically gone past the truck. And this would not have happened. And because that didn't happen, that means that the person did not have, that was inattentive, was, I'm getting a little bit into sort of the argument part of it. But the evidence shows that a normal reaction time, normal person with that much amount of seconds, this wouldn't have happened. And the jury could use that to say that either he was speeding, which there was evidence of that. It was a 45-mile-an-hour speed limit there, and there was evidence that
Yeah, the car's computer showed, I think, 42, didn't it?
correct. But there's also evidence from the expert that says that was done, I forget how many seconds or before. So to extrapolate, frankly, anyone's speed, 20, whatever the amount of seconds it was before to when something occurs is maybe not, it's evidence that you can attack. And so we're not talking about evidence here that a jury absolutely has to believe. Not talking about that, but
What
we're
I'm trying
talking
to
about.
figure it out is, how does the jury even find out, is there even evidence to support a factual basis?
Mhm.
The testimony is based upon sufficient facts or data under
Right.
the evidence. And so how does the jury determine where is this expert saying this braking maneuver occurred? Let's use the palm trees. If
Sure.
you're telling me,
Right.
Judge, look at this paragraph. It says, at the second palm tree, I see a braking maneuver. In between the second and the third, I just don't see anywhere in here. And maybe I missed something. Where is?
Right, and I think how the expert testimony came out is that, because there was really two sort of baskets of it. There was the accident reconstruction as part of it that said if he was going the speed limit of based upon what we know about the distance between the trees and all those kind of photolimic analysis that they did, phototrimetry, I think it's called. I probably butchered that, but that expert says if he's going to speed limit, then he should have been then this wouldn't have happened. And because of this, his analysis that he believed he was going upwards of 50 miles an hour, and therefore he was speeding. Now, that does feed into somewhat what the human factors expert can say too, because the human factors expert can say, well, if he's speeding, then that means he's going faster here. His perception time is going to be, the same perception time, but he's traveling faster. So-
You're in
so-
your rebuttal, just so you
Oh,
know.
I'm sorry. And so if you kind of link the two together, the jury either has evidence that there was speeding involved, which would be negligence just by itself. Or that the combination between the speeding as well as perception time meant that he was being an inattentive driver. And that was the evidence that was before the court. The court didn't look at any of that.
What you're suggesting is 24. Peter said, hit the brake somewhere in between, which your expert is assuming it's all bicycles as opposed to entering an intersection. But it's still going to be speeding under your analysis. Or entering the.
Yeah, the speeding would have happened before the braking happened. So the braking happens from the expert analysis of 5. He brakes, and then as he's braking, obviously the speed's going down. That means he's not speeding at the time of the impact. So the,
Assumption that it's breaking. If you're actually thinking something breaking related to
slow down the vehicle.
some of the reasons to break it.
Correct. Correct. And frankly, either one would be, I mean, if he's slowing down to go through an intersection, then that in and of itself is showing that there's some kind of care he's doing for that, but some kind of care that it's part of the negligence standard, right? Reasonable care. If he said very clearly that he was just going through the intersection. It wasn't a situation where he was braking because he brakes at every single intersection he comes to. He just said he was going. And so the only plausible explanation, at least from the plaintiff's side, of him braking going into an intersection is because he saw something. I'm going with my borough, but I will
Okay.
get the rest of my time for a road. Thank you.
Good morning. May it please the court. Sharon Degnan here on behalf of Kubicki Draper, representing the appellees, the defendants below, Thomas Becker and Jensen Underground Utilities. We're here today asking the court to affirm the summary judgment and conclude that the trial court properly concluded that Mr. Hester was the sole proximate cause of this accident, and that his decision to cross a busy intersection and essentially dart into the path of my client was the sole proximate cause of this accident. Now,
Could you respond to Helen's argument that begs the question? Did he dart in front of your client, or did in fact your client see him before he testified that he saw?
well, I think.
Based on the.
Correct. I mean, I think obviously that's sort of the whole issue here. And, it's our position that the video in this case and all of the opinions that were given by the experts in this case, which are based on this video, is what allowed the trial court to properly conclude the way that she did in this case. And this case really does come down to using the analysis in Scott v. Harris, that where there's two versions of an event, one that's supported by a video, the court is not required to give credence to a version of an event that is a fiction, in the words of the US Supreme Court. And I think really that's the important point here. And I think several things that my opponent were saying in terms of what the experts' opinions were is not accurate. And I think it's really important to pay attention, especially to the plaintiff's accident reconstruction affidavit, Bill Fisher, because what his opinions were with respect to, I agree, there are two aspects of this case that they claim constitute the negligence in this case. It's speeding and his reaction time. With respect to speeding, even Mr. Fisher, after he did his photogrammetric analysis and his braking analysis based on the video, he concluded my client was going 40 miles per hour. It was only this so-called alternate analysis that he did, which were based on certain facts that clearly are not shown in the video. He assumed, in order to say that my client was going 50 miles per hour, 5 miles over the speed limit, you'd have to assume that he was fully braked by that second palm tree. And I know, Judge Cohen, you said you watched the video a bunch of times. I probably watched it 5,000 times. Everyone, so there's no way you can make that finding. And I was at home stopping. I mean, there's no way that that happened. And if you,
There's no way that.
there's no way that that happened, that he was fully stopped at that second palm tree. And if you look at he said he was fully braked, correct. And if you look at Mr. Fisher, the accident reconstruction, that's not even his opinion. His opinion was that he was going the same speed through the second palm tree, and it wasn't until the third palm tree that he started braking. So we don't, in terms of his opinion, the first part of his opinion is based on the facts. It's this alternate analysis.
So counsel indicates that this isn't a real-time video. What is the relationship between the video and real time?
I don't know how to answer. Are you asking from a scientific perspective? I mean, I
Well,
think,
is there, yeah, is there any evidence as to, what the differential would be between what the video shows in terms of time and what would be in real time?
I don't think there is no evidence of that. But I mean, I think the important part is that if you watch, I mean, there's certain things that you can see
I'm
happen.
sorry to interrupt, counsel, but maybe, and I'll ask Mr. Lee when he comes back, but is there a dispute? Do both sides agree, or is that also another dispute as to whether the timestamp on the video is accurate?
I think everyone, as far as I know, there's no dispute as to that. I mean, I think
That it's
20
accurate or inaccurate?
accurate. I don't
Okay.
think anyone's made an issue as to the timing. I think the exact time, it was like 2:03, 03, and then, right, like 5 seconds. Okay, right, that would be right, because it's 2:03:57 would be 5 seconds before. So when you try and look back, so I don't believe there's an issue, Your Honor, with the timing of it. But I mean, I think the issue here is the basis, there really is no dispute with respect to speeding in particular, that he was not speeding unless you look at the so-called alternate analysis. And I think that's the basis that the trial court rightly did not have to accept, because it's not based on the facts in the evidence. It's it's refuted.
Right, and go ahead and articulate what you think the alternate analysis is.
What Mr. Fisher, his alternate analysis with respect to the speed is that if you assume that he started braking at that second palm tree and was fully braked up until the point he stopped, then you could conclude that he may have been going 50 miles per hour. But when he initially, in the first part of his affidavit, when he said he did the photogrammetric analysis and the speed analysis using the video, he concluded he was going 40 miles per hour. And I think that's the important thing here, because part of plaintiff's argument in their brief was that the lower court just ignored the plaintiff's expert's opinion, and that's not true. She utilized Mr. Fisher, their expert accident reconstructionist, his opinion, but the opinion that was based on the proper analysis, the photogrammetric analysis and the braking analysis of the video. So with respect to speed.
Counsel, again, are you arguing that because plaintiff's expert gives alternative opinions, that prevents the appellant from arguing as to a particular one that should have defeated summary judgment?
Well, no, what I'm arguing, Your Honor, is that this alternate analysis isn't something that the trial court was required to consider, because it wasn't based on the facts in the evidence. It was rebutted by the video. It was rebutted by my client's testimony, saying what he actually said was that he was driving, and when he got parallel with the first and second car, he saw a light, and he slammed on his brakes. And if you look at the video, that's consistent with what he did. So, but that was after that second palm tree. So that's alternate analysis is just based on facts that are not in the record. They're not record evidence. So with respect to speed, the trial court properly found that there was no evidence that anyone was speeding. Now, same with the reaction time. That opinion that from a graphical analysis, the bicyclist was able to be seen 5 seconds before, that is rebutted by the video. And Judge Stargill, I think you sort of suggested that when you watched it, I mean, there are cars to the left. My client testified there were 4 to 5 cars in the left-hand lane, and that is absolutely supported by the video that you can't see to the left. A driver would not be able to see. So again, to say that, oh, well, he was available to be seen, that is Scott versus Harris. If a version of events is rebutted by a video, the court is not required to give credence to that.
So I guess to turn the question that I asked to your opposing counsel, if the expert, the plaintiff's expert, opined that if this braking occurred at point A,
Mhm.
then here's my conclusion. what I hear appellant's argument is, well, then, in response to my question is, well, then the jury should look at the video and let the jury decide. I mean, don't we have to conclude that no reasonable juror could find that there was a braking maneuver at the place the expert said it?
Well, I mean, I think the answer to that is that if an expert says, if the braking began at the second palm tree, for example, and we know from a video that that is not the case, then that is exactly what Scott v. Harris says you do not have to do. And when Wilson Art, maybe under the old standard, you had to do that, you don't have, that's an incompetent opinion. And it's not a question, I know you had said about striking the opinion. I mean, that's what the cases say, that that opinion, the court doesn't have to give credence to a version of events or an opinion that's based on things that are a fiction. And that's really what that alternate analysis of Mr. Fisher is. And with respect to Justin Morgan, the human factors, I mean, his opinion is just solely based on Bill Fisher's opinion. So, you know, the way we look, it really comes down to, is there a basis for Bill Fisher to say that he was available to be seen 5 seconds before, when you can see that there were cars lined up? My client testified there's no basis for him to say that. You know, and I think one of the things that when I was listening to Mr. Lee's argument, I just want to make clear is that the only evidence here with respect to the experts is Mr. Fisher. It's just his affidavit. There was no deposition. I think the summary judgment hearing talks about it may have been taken, but it's not part of the record. And with Justin Morgan, the human factors expert, there's an affidavit and there's a beginning part of his testimony. So there is no, the evidence with respect to Mr. Fisher, it's just this affidavit. So, you know, our position is that the trial court correctly looked at the video and concluded that there were no facts for a jury to consider because there was no evidence that my client was negligent. There was no evidence that he was speeding, nor was there evidence when you look at that video that he was that the bicyclist was available to be seen 5 seconds before the impact. I mean, you can see right on the video that that's not the case.
Anything further?
If the court doesn't have any other questions for me, we respectfully ask the court to affirm.
Thank you. All right, a little over 2 minutes.
Yeah, thank you. Just to answer the question that I know Judge White hasn't asked me yet. No, there was not any evidence that the time on there was different. Like, we weren't saying that it was really 3 seconds before or after. That wasn't there. The affidavits, I was looking at them again. Dr. Fisher talked about this 5 seconds prior to impact, and then when the cyclist, my client, would have been visible. He said from a graphical and analysis of the scene, cyclist was available to be seen by the driver of the Chevy Silverado 5 seconds prior to the impact. And so he did an analysis of the scene. He talked about that analysis, and his analysis, he said that Silverado at height would have seen the bicyclist. Then he goes on to talk about the two scenarios.
He do that. And let me ask a more specific question that's raised by your opposing counsel. If the timestamp is correct,
Mhm.
I watched the video 5 seconds before the accident. The defendant's vehicle is not even on screen.
Right.
The plaintiff is barely visible to me. In the westbound side crosswalk. He's not even in front of the 2 lanes of blocked traffic. So how in the world does an expert say, here's what the driver of the vehicle saw based on what? I mean, clearly can't be on the video because we don't even know where the defendant's vehicle is off screen.
True.
He may not even be on that road, right?
Well, we know that he was on the road because of his testimony. He did look at the testimony of what the defendant driver was saying, how he was driving. He looked at the scene. He didn't just look
I'm
at,
sorry. So where there, so you're saying there's summary judgment evidence that would say 5 seconds before he was eastbound on that road?
correct.
Okay,
He was going on that road. He didn't like turn, the defendant driver didn't like sort of turn, just at the intersection before. He had been going on that road for quite some time.
and does his testimony say that there were no vehicles in front of him at all except those stop vehicles in the turn?
I believe that the only thing he said, and forgive me, I might be wrong about this, but I think what he said was there were the vehicles to the left, but that he was heading through the intersection. He doesn't say in his testimony that he braked at all prior to him seeing the flash and that kind of thing. So what we have is we have expert testimony based upon an analysis that the expert did of the video, the scene, this photogrammic analysis that he did that said 5 seconds before, even if it's not on the video, the expert could still opine that, look, because of where everything was, he would have been able to see the bicyclist 5 seconds before. That's important because the two scenarios come from that. One is if we believe the driver and the driver was going the speed that he said he would have, even with perception time, he could have just taken his foot off the brake and the crash doesn't happen. That's one. Two is that if the alternative analysis, so one actually says there's negligence. Two, if he would have been going faster, the 50 miles that between, and he braked at that point, which the expert says there's video evidence to show, then that meant that he was speeding, right? When he braked.
Counselor, you're well past.
Oh, I'm sorry.
your time.
Unless
Judge White, any further?
Yeah, I'm sorry. I was trying to answer your question. So,
Were you, can you finish? the
Sure,
question?
absolutely. Are you
no,
finished?
Or finish his
no,
answer?
absolutely. No, I was just gonna say that, the speeding comes into play, that he's going faster during that part, so that when the perception time and the braking happens, then that would have also not caused it, right? So there's two different things. He's either, he's inattentive or he's speeding. Those two things could both have, the jury could have used both to say that he was negligent.
Thank
Sorry, I went over my time.
Not a problem at all.
Thank you. We'd ask the court to reverse summary judgment. Thank you so much.
The fact that your client survived that was just absolutely
amazing.
amazing. Yeah. So, all right, well argued. Thank you both for your presentation. We'll be in recess.